Pay attention to that, guys, because they're going off of revenue generated and not the profit in your pocket.
Yep.
Think about that.
Yep.
Welcome back to another episode of the Mission Control podcast, brought to you by none other than your boy Mike Stearns, Ascend Digital, and the team at Roofer. Look, if you're a contractor and you're looking for clean and pristine proposals that will give your target audience no choice but to buy, click the link below. You'll see it. You'll be happy that you did. They also do things like roof measurements, online roof quotes. I mean, they're just great and a great team. So go check them out. Today we have a very special episode. So we've got Corey Combs, who you may or may not know, and if you don't, you should. So we're going to help you with that. And then we also have Mr. James O'Connor. He's an attorney that specializes in labor and employment law. We'll get more to that in a minute. But from my understanding, and I'm just a marketing guy, there's been some misinformation, some misunderstanding, and some lack of clarity around like W-2, 1099. And I also understand that it's been a point of emphasis for some agencies, and that could have some impact on your business now, tomorrow, next month, next year. So, while we're going to give you a lot of great information, it's very important to note, and James will attest to this, that this is not legal advice, nor should it be construed as such. So, without further ado, Corey, James, get after it.
Appreciate it. Thanks, Mike. Yeah, one of the reasons I wanted to do this podcast with you guys is because, I'm pretty active on social media and a lot of the contractor groups. What I keep seeing, and James is my attorney, I've been working with him for the last, 4 years or so, developing contracts, trying to stay compliant, trying to stay ahead of some of the changes that these agencies have made. And I notice in these contractor groups that there's a lot of bad information, either completely wrong, misinformation, or just flat out nonsense about how you classify your employees and how you stay compliant with independent contractors. Plus, recently, there's been a lot of things that have changed with the IRS, the Department of Labor. And so I wanted to talk about those changes, how they're going to affect contractors, how they're affecting contractors now, and what we can do to stay compliant. So I'll let you introduce yourself, James.
Sure. Thanks for that. Thanks, Mike, for having me on. And thanks to Corey. James O'Connor. I'm an attorney at the law firm Phillips Lytle in Buffalo. We have 8 or 9 offices at this point. Or throughout the Northeast. And because I'm a lawyer, I have to add as part of a disclaimer that my opinions are my own and not Phillips Lytle, the firm where I work. But I'm a partner. I've been practicing in labor and employment law for about the last 10 years. I do a lot of employment litigation as well as some labor negotiations if you're a union workforce. Part of my practice is also what we call counseling, which is when there's not an active lawsuit pending at the time, but a client such as Corey or someone like him calls up and says, I have this issue, we're trying to hire this person, they really want to be a 1099, what can we do? And my role in that capacity is more of a counselor, and we talk through those issues because it's not a one-size-fits-all approach. And there's no cookie cutter answer to some of these questions. Everybody's business is different. Everybody's appetite for risk is different. And there really are no one set of rules that will apply across the board, which I think is part of the problem that you're seeing on your social media groups and search boards, whatever it is, that people think that because something works for them, it must apply in all situations. And from what I do in the legal world, that's just a very dangerous precedent. And we've really got to be cautious about doing that. So, I'm thrilled to be here, excited to talk about this. I love nerding out about labor and employment law. Yeah. And hopefully nobody has to ever deal with an investigation by one of these agencies or a lawsuit by an employee or, God forbid, a group of employees. But one of the ways that we can mitigate that risk, because it is a risk, is to deal with it on the front end and be proactive. And so I'm excited to be a part of that. So thanks for having me.
You're very welcome. So if I'm a contractor, it just seems to make more sense to get free advice posted to 20,000 other contractors and like hear what they have to say. Is that not a good idea?
That's absolutely not a good idea. I mean,
or go to TikTok. No?
that's where I get my news. So I mean, yeah, that's a little bit of, the blind leading the blind, so to speak. And just like you wouldn't want to listen to a bunch of lawyers talk about how to market or how to put a roof up. I heard it was this way, so I'm going to say that that's the only way to do it, and it works in all scenarios.
We get that sometimes.
I bet you do.
I love you all.
Yeah, that's a good point.
Was there something, Corey, though, that happened in your business that kind of sparked the interest in having this conversation?
Yeah. So last year I had a problem with one of the people on my sales team. He was 1099, and James and I have iterated our independent contractor agreement a few different times to try to meet some of the conditions that we had with some salespeople. And what happened with this person last year really was the catalyst for me to make everybody W-2, just based on some of the changes that have come down the pipe. Some of the things that James had counseled me on from a risk management standpoint, and then knowing what the legislatures were working on to bring some of the new changes that were going to happen in 24. So even though this person that worked for me they were technically independent because they were doing another sales position in a different industry. So I think we would have been fine if we would have gotten into a lawsuit with him, which, by the way, I fired that person. I owed them a bunch of commissions. There were jobs that, that they had undersold. And I got an email from this person that basically said, because they kind of knew that I wasn't 100% compliant with the rules and the laws.
Allegedly was not 100% compliant.
Allegedly wasn't 100% compliant. Thank you, sir.
You're welcome.
That I didn't want to open up myself to an investigation after seeking counsel from my attorney. We decided that it might be a good idea to just settle, right? And so we did. I personally knew that I didn't want to go down that road with either a lawsuit or an investigation and all of that stuff. So it cost me quite a bit of money. We decided to go that route. And then we also decided to start making some changes, going to W-2, so that I could further reduce my risk of getting in this situation again. So to maybe give some clarity on this, can you talk a little bit about the agencies? I know there's 3 big ones. And then what are some of their rules and guidelines, just basic rules and guidelines for 1099 versus W-2? And then we can sort of get into the changes and how those affect contractors.
Yeah, absolutely. So there are 3 big federal agencies that care about whether you're properly classifying your employees. And those are the IRS, the NLRB, National Labor Relations Board, and the U.S. DOL, Department of Labor. There also are myriad state agencies, depending on which state you're operating in, that also care whether or not you're classifying them as employees or 1099 independent contractors. And unfortunately, not all the agencies have the same test. It would make things much simpler to do business if they were, but they are not. And so it's important to understand that when you're seeing some of this information out there, it may technically be true, right? Somebody posts something on one of these groups or message boards that says, as long as you do these 3 things, you're good. That may be true for one of the agencies, but it may also not be true for one or more of the other ones. We want to be compliant with all of them, right? So, generally, for instance, the IRS looks at 3 types of areas when they're determining whether or not you've properly classified your employees: behavioral, financial, and the type of relationship. So, behavioral is, do you as the employer have the right to control, or do you control the work that is done, how that work is done, not the result, how it is done. If you do, Sorry, they're not an independent contractor. They're an employee. Financial, are the business aspects of the worker's job controlled by you? For most of us, I think the answer is probably yes. How that person gets paid, whether expenses are reimbursed, who provides the tools and supplies. If you as the employer are the answer to some of those questions, guess what? You're the employer. They are an employee, not a contractor, under the IRS regulations. And then the third is, the type of relationship, which is, in my practice, I have seen be less important to the IRS these days, but it essentially means, are they allowed to have or provided, benefits that are typical of an employee, like vacation pay, insurance, things like that. Now, you may see on a message board, as long as you don't pay them insurance, I'm just making this up. As long as you don't pay them, offer them insurance or provide them with vacation pay or other employee benefits, you're good. They can be 1099. That's not true. The IRS would look at other aspects, mostly the behavioral. So to take a statement directly from the IRS guidance, they say the general rule is that an independent contractor is an independent contractor if the payer, you, has the right to control or direct only the result of the work and not what will be done or how it will be done. So you mentioned sales.
Oh, wow. Okay.
I'm thinking to myself, because I know a little bit about your business, do you distribute sales manuals? Do you have trainings on how to close a deal or present a sale? Do you have trainings on how to enter sales once they're made into a process or a workflow, something that maybe Mike has designed? If the answer to any of those is yes, according to the IRS test, those folks are employees, not independent.
You're violating the rules.
You are directing and controlling how the work is done. And for that reason, you are their employer and they cannot be 1099. And that's just the IRS, right? And they admittedly are not, really the ones to be worrying about. The ones that I worry about are the NLRB and the US DOL, because those folks they can issue some serious penalties. With the IRS, you can work with them, in my experience. But
so let me give you guys sort of a simple way to look at this. If we have sales training that we're providing to our 1099s. So for an example, if you hire a consultant and they have a standard operating procedure, a sales process that you're training them on how they need to sell in your company, then that violates the IRS rules, correct?
it certainly could. Yes.
Okay.
Yep.
Now, if we're using a CRM and we're telling them, hey, listen, this is how the information needs to be put in. Here's how your contracts have to be done. Here's the contracts that you have to use. Here's the estimating forms you have to use. All of those things could be in violation of what you just described, correct?
Yes. And in that instance, it is more likely that they would be considered employees rather than 1099s. I can't think of any other way of explaining to an IRS investigator or a court how, given what you just described, you're not directing how the job gets done. Right. So with a straight face, how am I really going to work with an investigator and say, hey, look, I know you're doing your job, but these guys really are 1099. I can't say that with a straight face if all those things are true.
So if you couple that with you're providing shirts and you're providing trucks and you're providing cell phones and you're providing all of that. So now we're looking at everything in the totality. Mm-hmm. Okay. So we're giving them a process to follow. We're directing them how they sell their jobs and where to put the information, what forms to use, all of that stuff. And they're wearing our shirts and hats and they're doing, giving them trucks and all that stuff. Now, there's really no argument to be had that they're 1099.
I would absolutely agree with that.
Yeah.
It seems next to impossible to create an environment where a salesperson could be 1099 then.
It's difficult for sure. And I think that is by design. I think that I know these agencies, particularly the NLRB and the USDOL, they have issued memoranda and guidance that explicitly states that they are moving towards a model where folks are going to be classified as workers rather than independent contractors. And the policy reason behind it is they want to make sure the workers are all entitled to any and every right as an employee that is available to other employees under the law. And those memoranda are coming from, like, for instance, the chair of the NLRB or the general counsel for the NLRB. The fact sheets on the USDOL website, they all indicate to me that they are moving towards wanting folks to be employee versus independent contractor.
That's crazy because, like, from my understanding, from what I've observed, it's not always just the employer that wants the 1099 and the benefit of that. A lot of the times that's the employee, the independent contractor that's like, I don't want to commit to this. I don't want this level of control, but I guess what they perceive as an acceptable level of control versus what one of these agencies perceive as an acceptable level of control, it seems to be, quite an imbalance there.
Yeah, that's right. And unfortunately, all three agencies are explicit that just because you say you agree that you want to be an independent contractor doesn't mean that you are an independent contractor. Even if Corey and I were to say, I want to be independent contractor, I don't want to be a W-2, we put it down in writing, and we sign. And I even say, I'll waive any rights I have to claim I'm an employee. Doesn't matter. The agencies, if they wanted to, if they're motivated, they can come in and say, despite all of that, we view you as a W-2 and we're going to penalize you accordingly.
I have a quick question. So from my limited understanding, because again, I'm just a marketing guy, with like the IRS, right? And like write-offs and deductions, there's certain things that you could do that would maybe draw more attention to yourself. If that is true, does that same theory apply to like these different agencies? Are there certain egregious missteps that contractors make to where it's like, okay, we're putting a target on your back?
Yes, absolutely. And I think that's part of the reason why you did what you did, Corey, is because there are certainly things that you don't want to do or have done to you that put you on their radar. So with the IRS, you're right. It's crazy deductions, crazy write-offs. Some bean counter is going to look at that and say, hey, this looks funny. Escalate this. We're going to review it a second time. And once you're on their list, I'm sorry. It seems to me like you're on there forever.
VIP list you want to be on.
Right. Yeah. That's at least been my experience anecdotally from clients I've worked with is once they think they have somebody who's a violator, they're going to stay focused and check in every few years. So with respect to the independent contractor, it's really about minimizing the risk that your workers are going to file a complaint, because they do have the right to file a complaint even when you settle. You may remember this from our settlement agreement.
Yep.
Even when you're paid money to walk away and release your claims, you cannot by law waive your right to file a complaint with one of these government agencies.
Yep.
You're only waiving your right to recover money. Exactly. So in reality, I've been doing this for 10, 11 years. In reality, when you pay somebody to go away and you sign an agreement, even though they are made aware, they can still file and still make your life hell, Corey.
Yep.
I've never seen it actually happen. They always just go away.
Mm-hmm.
Doesn't mean it hasn't happened. I'm sure it still does happen where somebody takes their money and then says, you know what, I really want to give it to my former employer. I'm going to file a complaint anyway, even though I can't recover anything from it. And I'm sure that does happen, but it's got to be few and far between because I've never seen it. And, I do these things quite regularly. So minimize the risk that your workers are going to file a complaint. And, the other piece is if you're making, the type of money that we all want to be making, right? And you have no W-2 employees, that's going to be a red flag.
Sure.
That's going to be a red flag.
So let me ask you this. I mean, and I'll kind of put this in contractors' terms here in just a second, but this spurred me to ask a question. If you are non-compliant, meaning you have some 1099 salespeople that you're skirting the rules on, and you do finally get compliant, is there a way, or is there a statute of limitations where they can retroactively go back to that period of time where you were non-compliant? And,
I'm going to say yes, but let's see what the attorney has to say.
Yeah, the answer is absolutely yes. And it varies how far back they can look depending on which agency you're talking about and which law being violated. IRS can look back 6 years or 7 years on most things, which is why we always recommend you keep your records for that length of time. Some of the other agencies like the DOL can look back at least 3 years. State versions of or iterations of the DOL can also look back longer than the US DOL. New York State can look back 6 years on certain things. So yes, absolutely. I will say that if you're under an investigation by one of these agencies and you have made a good faith effort to comply, whether that's before the complaint or even after, it does go a long way. If you've got the right investigator and frankly, the right lawyer, who can sit down and talk to this person and say, hey, look, this guy's just trying to make a living, and here are all the steps he's taking to ensure compliance. But like the IRS, they will trust but verify.
Sure.
They will check in and make sure those controls that you've put in place are permanent.
Sure.
Absolutely goes a long way. It's not determinative. You can't just say, sorry, my bad.
Right.
But it may limit the vigor.
Does it take it from first degree murder down to manslaughter?
Similar to that, sure.
Yeah.
It definitely reduces the vigor with which they are seeking their pound of flesh, because that's what this is all about, right? Let's call it what it is.
Yeah, and I want to get into this here, seeking the pound of flesh. But go ahead and finish, and then I'll.
They want to squeeze out as much as they can. I'm sure that they probably are good people, and they're probably nice people. Don't get it twisted. Their job is to secure money for their agency. And yes, it's about enforcing the laws, and yes, it's about workers' rights. But at the end of the day, these folks need to justify their existence.
Yes.
To their bosses,
yes,
right? The higher ups and the federal government and Congress, who authorizes these agencies to exist. And what better way to justify your existence than to say, we've brought in $3 billion in
penalties from,
and I'm just making that number up. I don't actually know. I'm too scared to look into those numbers because I'm sure it's a high number.
We helped out this many independent contractors that were actually employees.
Right. And 9 times out of 10, that money is not going to those folks. It's going to the agency. When it's a penalty for a violation, it's the same across the board. It's the same with OSHA. It's the same with all of those agencies.
Yep.
It very rarely actually trickles down to the employee or worker.
Because it's really, at the end of the day, not necessarily about compliance. That's the lever to get the money.
Yes.
And so let's talk a little bit about, why people violate these rules, right? And from a contractor standpoint, there's and I don't want to say it's just a contractor violating these, because it's not, right? On the sales, when I transitioned everybody over to W-2, the big objection from the sales team was, of course, that now they're going to pay more taxes because they are W-2. They don't afford the same write-offs and things like that as they could when they're an LLC or an S Corp or whatever. So It saves taxes for the salesperson, so that of course they want to do it. And I think that's why they put that mechanism in there, so that it doesn't matter if you make that agreement or not, because they understand that people are going to make that agreement all day long because it's financially beneficial to them. Yep. And then on the contractor side, we save workers' comp, we save state and federal income, and there are some other fees and taxes that we pay on top of when we have W-2 employees, like we pay into unemployment. So there are a lot of things that benefit us if we don't have to pay those. There's also laws on the books in a lot of states where you have to have benefits, paid time off, paternity, maternity leave, things like that you don't have to offer once those people are 1099 or independent. Yep. So talk a little bit about that and why people do that, and sort of what the agencies look at from their standpoint to recover that money.
Sure. So it's absolutely a risk management analysis, and every employer is different, and every business owner is different and has different goals, different appetites for risk. So there certainly are situations where looking at all of those negatives that you just described with being a strictly W-2 workforce, which admittedly, there's a lot of negatives to making them W-2.
There is.
It's costly. I get it. And for some employers, maybe it is worth the risk of being found in violation. Given the amount of money that you would save by having these folks be 1099, set that money aside and save it for a rainy day. If you do get whacked with a violation, you're still up. You've still made money. Not every employer is like that. I think the calculus for you was, it's not close to being worth that. It's going to depend on the amount of revenue that is generated, not necessarily the amount of profit going into the owner's pockets, which is a big difference.
Pay attention to that, guys, because they're going off of revenue generated and not the profit in your pocket.
Yep.
Think about that.
Yep. Other factors include the length of time of the violation. Some of these penalties are daily violations, particularly with the NLRB. And they can be daily violations of $1,000, $2,000.
Okay, so you're telling me that they'll look at it from the length of time that you engaged in the relationship with that person all the way through to when the investigation started. They'll fine you per day?
They could. Yep.
Wow.
Yep. And part of the reason why those investigations are so costly is forget about the lawyer fees, which I, again, concede are going to be substantial. If you're a major company and you're doing a ton of work and you've got a ton of employees, or workers, I should say.
Okay, would you clarify that just a little bit? Because we've got people that are going to be from 1 to 2 employees all the way up to some of the larger companies that are going to have 20, 30, 40, 50 employees. So how does this affect the smaller guys?
So with the smaller guys, it's really about mitigating the risk that somebody files a complaint, period. Because if they do, and you are so small, to use for lack of a better term, if you're really operating on thin margins and you're, more or less just scraping by, something like this could ruin you. It just could.
Sure.
If you can't afford, a $10,000, $15,000 fine plus a $5,000 legal fee, you may end up closing up shop over it. Now, if you are slightly larger than that, but not much larger, it may not affect you as much. You may look at this as, geez, I really can't afford I'm just going to throw out numbers. I can't afford the $100,000 a year extra it's going to be for me to make my 10 employees or 5 employees, workers, W-2s. I'm going to roll the dice and just hope and pray and treat my workers well and hope that they don't file a complaint. But if they do, I'm gambling that the amount I'm going to pay the government is going to be less than what I would pay to convert them to W-2s. So those folks, it may not matter much. The larger you get, the more likely it is, in my experience, working with folks such as yourself, you're going to want to convert them to W-2. Because the number of employees, one person files a complaint. Well, guess what?
They're looking into everybody.
You got it.
Yep.
You got it. And, it's not technically a class action. It's not called that, but it's the same concept of if they get, a piece of red meat in their teeth, these agencies, they're going to be digging through and seeing how deep does this rabbit hole go? And if they think that there's a pot of gold at the end of that rainbow, guess what? They're going to be hunting. And if you've got 50, 60, 70 employees, that number can get real high real quick. This is not even considering the fact that under a proposed rule, you could be deemed a joint employer of your subcontractors, not necessarily for this purpose, but in general. And now, instead of your 70 independents, you could be potentially responsible for
everybody you do business with.
Whoever's up on the roof.
Roofing subcontract, anybody that you use for labor, for an example.
Yeah.
And we'll put a pause on that because we're going to dig into that here in a little bit, about some of these proposed legislations.
I have a question. So some people may or may not make an informed decision to say it's the juice is worth the squeeze. The upside's there. I'm going to roll the dice and see if I don't get caught because I can't afford to pay $100,000 to have these 10 W-2s, right? They're going to be independent contractors, and that makes sense for me. Now, I'm not an attorney, but from my understanding, let's say the difference between murder and manslaughter is intent. So is that a contributing factor when one of these agencies decide to pursue a case if they feel as if there was malice and you intentionally did it? Does that make a difference?
Sure, absolutely. It's not determinative. You can't just say, I was trying to do my best. I really didn't mean to do this. That's not going to win the day, but it absolutely will go a long way in minimizing your penalty. Second time and third time offenders absolutely get hit way harder. And that's obviously shows an intent, all right? And a willful, malicious intent to skirt the rules. Unfortunately, it's not necessarily a significant savings in many instances where you can truly establish and connect with the investigator who's, a person like all of us. And you can connect with them and say, hey, look, this guy's responsible for 30 families who work for him. And he's, really doing his best, thought he was doing the right thing, got some bad advice, right?
Off a Facebook group.
Yeah, right. And it may help a little bit. They may knock a little off, but it's certainly not going to be a wash.
I mean, I could see, I own a business. I started a business, and what I thought I was going to have to know versus what I had to know was markedly different. And, I mean, you think of all the things that you're trying to figure out on the go with a gun to your head to meet deadlines and all these different things, and I could see it being very easy to stumble into this situation without any malice, without having any idea that you're violating laws, right? Yeah. So I'm for the people. Mike Stern's man of the people. So shout out to all my contractors out there that are in this situation and just didn't know it. I feel like that's the vast majority of you guys. So that's why we're having this conversation.
Yeah, I mean, unfortunately, ignorance of the law isn't a defense, which I've found that out a couple different times. And the precarious spot that contractors are put in is, we're trying to, let's be honest, you cannot follow the letter of the law and stay in business. It just doesn't, it's so expensive.
You'd go broke.
You'd go broke. If you paid every single tax and you'd go broke. There's no possible way you could do it. But let's say that you have a violation, you get, you get investigated, you go through all of this stuff. You're telling me that they would have no problem fining you out of existence, basically.
Sure. Absolutely.
And we'll tag these agencies down in the description.
Write your local congressperson and tell them you object to their existence of these agencies. And yeah, no, I've seen it. It absolutely can happen. Especially if you're just starting out, some of the worst parts of my job are when it's usually a young person and he or she is wide-eyed and going to change the world. And,
oh man! Yeah.
And they start their business and they truly are doing their best. And for whatever reason, a disgruntled worker, I don't want to call this, them employees, but a disgruntled worker files a complaint. And, these agencies come in and they want to look at all the books, and then you're getting audited by the IRS. And these new business owners, a couple of them I've seen 2-3 years in, they still haven't turned a profit and for themselves. And, they're not taking a salary. Even a $10,000 fine closes up shop. Seen that happen twice.
Yeah.
That's sad.
Yeah.
That's sad.
So have you seen an instance where, let's say like the Department of Labor gets called in and the books aren't necessarily up to snuff, right? And they're trying to pull out all the numbers. Have you ever seen it where they call in the IRS because the books aren't good and they're trying to determine what's going on? So they're like, hey, we need to check the taxes and all of that stuff. Yeah. So does that happen?
I've never seen it, and I don't know that it happens above board, but I do know that when you get investigated by one of these agencies, your likelihood of being investigated by another one in the next 5 years is high. And they have issued memoranda, these agencies, encouraging their field offices around the country to work closely with their sister agencies. And so it definitely is becoming more of a thing. I've never seen it where they flat out admit to me and say, hey, your client, their books are terrible. We're calling the IRS. I've never had that conversation. What I have had happen is a DOL comes in, they're getting a wage and hour complaint. Somebody's saying I wasn't paid by all of my lunches or my meal breaks, or I should have been paid overtime. And a wage and hour audit can be very long, and it can be, they want to look at everything, right? And what I have seen is we close out the wage and hour investigation, we come to an agreement, some money is paid. That next year, increased audit from the IRS, secondary audit, and surprise, surprise, hit with some violations. Not deemed willful in that instance, thankfully, but I mean, the IRS, they still want their money. They just don't want a penalty on top if you can prove that it was innocent. But if it happens again, I mean, you better believe they're coming for the whole kit and caboodle.
So are you telling me? So are you telling me that there are compliance things on the, and I'll ask you this question a little bit differently in a second, but there are compliance issues with the relationship with 1099, so independent and an employer, but there are also compliance issues with W-2. So there are some laws and regulations that if you do switch everybody over to W-2, there are some state laws, and obviously we can't get into those because those are going to be, based on the state that they're in. But you're saying that there are compliance things that we need to be aware of, even if they're W-2.
Absolutely. And when you make somebody a W-2, and this is, again, probably part of the problem you're seeing on your Facebook groups and message boards, is that making somebody W-2 does not automatically put them into one category of W-2. You can be a W-2 exempt employee, meaning I work 45, 50, 60 hours a week, but I'm not getting overtime because I'm exempt from it. Or you can be non-exempt, your typical hourly workers.
Well, we did outside sales, right? So talk a little bit about that.
We did. And so there are other exemptions under the Fair Labor Standards Act, FLSA, that allow you to have W-2 employees, so you're still taken care of on that front, but they're paid commissions, for instance, and they're not entitled to the minimum wage and overtime requirements that a typical W-2 employee is. With respect to the outside sales, there are certain factors that need to be met. The main one is outside, right? Don't give them an office. Don't give them a place to work. If you do, now they're not an outside salesperson. And guess what? They're entitled to a salary or their hourly rate based on the minimum wage, depending on your agreement with them and what state you're operating in. And I don't know about you guys, but I clock sometimes 80, 90-hour weeks from time to time. And so if I were to discover that, unbeknownst to me or my employer, that I really am not an exempt employee, that overtime, time and a half of an additional 40.
That's a lot.
Especially with what you build.
How's it going? I'll take it. I can take my medicine. It is incredible though that the fact that you're paying somebody a commission based on sales, and because something as you would think trivial as we're giving them an office.
Yeah.
We're telling them we want to see them from time to time. They got to come to meetings, things like that. Now, all of a sudden, they're W-2 or not W-2. They're not exempt, and you can't just pay them straight commission. That's the reality. So that's why we're very careful with your outside sales team, because that exemption is important. I think if they're doing their job, they're going to want to keep their commission agreement because they're going to be making a lot more than a minimum wage.
Yeah. But
if they're not, and if they're slackers or having a bad month, maybe they do make more money if they can just say, hey, I was working 70 hours and I'm not a true outside salesperson. Corey Combs should have been paying me time and a half for every hour I worked over 40. And, that's a real concern. But I think the point is just making somebody W-2 doesn't mean necessarily you have to track their hours and start making them, eligible for time and a half and minimum wage. There are exemptions to work around.
So that's where, when you and I originally had the conversation, I'm like, look, man, I don't want to have to deal with all of this W-2 stuff because, my payroll company was like, okay, you got to track all their hours and you got to track this and you got to track all this. And, I'm like, look, I'm not doing that. So we went in, and if you're listening to this, pay attention, okay? Because we're talking about the sales team mostly because that seems to be the biggest issue. We're going to talk about labor here in a second, but for a sales team perspective, most of us, we don't do traditionally inside sales, which means they're not in an office using the phone, calling people, doing sales in there. We're going to people's houses or buildings or whatever. That is their primary function. They're not working out of the office. So what we did, we classified them as W-2 outside sales. I put together a bullpen in the office where we had a bunch of cubicles. None of them belong to anybody. If they need to come in or they need to park there to do some work, they can. They're not required to because they work outside. And so that was one of the big things that we wanted to make sure. There's another misconception that you cannot have a W-2 employee that gets commission only, which is not true. Right? There are certain classifications of W-2 that you can pay commission only, and this outside sales was one of those classifications.
That's correct. Yep. And one of the examples, these agencies love to give examples, and so that they can make their regulations clear. One of them is an outside salesperson typically conducts their sales in customers' homes. Right. I know for a fact that that's a lot of what your team does is they're going out and selling jobs and meeting with customers at their homes. That is
Or businesses, by the way, those
commercials.
Yes,
That's
commercial
right.
works as well.
Yep, absolutely. And I think that no one factor is determinative in any of these tests, which is a fancy way of saying that these agencies will do what they want, and they will work with you if they want to. But if they want to screw you, they can, because they can rely on this. No one factor is determinative. Some of them even say there is no magic test. That's the official legal term that they use. No magic test, which in reality means if they want to get you, they're going to get you. And that applies whether they're 1099 W-2 or whether they're W-2 but should be paid something different than straight commission, which in some states that's really hard to do. For instance, New York State, that'd be pretty difficult to do. Giving somebody a W-2 status here in New York carries with it a lot of other benefits to the employees that where you're operating may not necessarily come into play.
It does not. That's why I love Florida.
Yeah. So you can just pay them straight commission. You don't have to worry about vacation pay and paid family leave and all that sort of stuff. In New York, there is a commissioned salesperson exemption under the New York labor law. But it's not the same as it is down in Florida for you. So that's why everybody's different. And that's why you cannot take a cookie cutter response or fact of the law and apply it to your business without talking to somebody who knows what they're doing. You just can't.
So let's say I'm a small contractor listening to this, and I'm in Pawtucket, Rhode Island, and this was so eye-opening, and I really want to do the right thing. But the problem is like we're not making a ton of money. We still got positions that we need to hire, and I just can't seem to make this a priority because there's other things that are essential and vital to my business operating and growing that have to be pursued. Like, when is the right time, and like, what does a roadmap look like to compliance and better understanding this? Because you guys are expensive.
We are. That's right. And the answer is today, right? Sooner rather than later. There is no time better than the present. Why risk going another day and having another $1,000 or $2,000 per day fine adding up? I look at it as, yeah, you can pay me or somebody like me, $1,000 or $1,500 to do an audit, a sweep, and check out how things are looking and what your risk is. And that sucks. Nobody wants to do that. Or you can pay somebody like me $30,000
to defend you.
Yeah. And that's, the initial retainer.
It's far less palatable.
See what I mean? So, is there a chance that you don't pay me or somebody like me at all and you never get audited or investigated? Absolutely. And for some businesses, maybe that $1,500 savings, and I'm just throwing out numbers, maybe that's worth it. I know for somebody like yourself, it's not even close. I mean, you're going to rather dish out the couple of grand to get it squared away rather than get whacked on the back end, because given your size and the amount of revenue you're doing, it's not only what you're paying me, but it's what you're potentially paying these regulators.
What's your peace of mind worth to you?
Yeah, I mean that's a great point. I mean the more you grow, the larger you are, the bigger target you have on your back. And somebody told me that a while ago, and it's so true, because even though you do the right thing, you try to take care of your employees or your independent contractors and all of that stuff, things happen, relationships sour. When money's involved, people get weird. And so, I'll give you a scenario. In our agreement, we have a commission agreement where our sales team has to meet certain margins in order for them to be able to recover their full commission. So the less that job hits margin, the less commission they make. Well, every single time when you have to dock their commission, there's always a conversation about it. Like, oh, what happened? Who screwed me? This, that, and the other. And I'm very transparent with our P&L, so I can show them like, hey, this is where you screwed up, right? And this is maybe why it's a good idea to get compliant because I've always provided my team with the estimating tools, right? The pricing, the tools, the platforms, everything to do their job. And so their argument is like, hey, I'm using the tools that you provided me. Your tools are defective, right? That's always the argument. It's never their fault, right? It's always something that I did. Yep. And you have enough of those conversations and you have enough of that conflict, the relationship starts to sour. And that's in the case of the person that I paid out an obscene amount of money, which I lay at bed at night sometimes still thinking about it, pissed off, okay? Because I was 100% in the right. Yeah. There's a really good argument if you're going to operate like that to make sure you're compliant, because you need to be able to stand firm in your position without letting your sales team run over you if you have an agreement like that in place.
Right. And just to clarify, I mean, you mentioned that you provide all the tools and you provide the training. That is one of the reasons why we opted for, okay, let's make these folks W-2, because guess what? They are. Mm-hmm. These agencies are going to designate them as such based on probably solely that fact right there, that you provide that stuff for them and you direct them on how they get things done. Now, it doesn't mean that they're a straight W-2 that has to get, all the benefits that come with it. They can still be straight commission. They're just W-2 rather than 1099. Mm-hmm. And yeah, I mean, I think that's absolutely right. And some companies may be comfortable with that risk, and some companies may be so stubborn that, in the case that you're referencing with the gentleman who worked for you, they may say, no, we're not paying him a dime. Let him call. Let him file a complaint. And, he would have. He would have. And what would have happened is your other employees or workers would have been found to be W-2s. The amount that you paid this gentleman, you would have paid 10 times that to the DOL.
Please don't file a complaint still. So where do they delineate? So, okay, I'm Corey. I've got a sales team. They're operating within confines of my roofing company. We have standard operating procedures. We have these tools. Is it the fact that he requires them to use this versus here's a link, you can use this measurement software if you so choose. Here's a software that we use. This is why we use it. This is how it makes your life easier. But you don't have to use it, right? Is it giving them the option versus mandating them to use it that becomes the problem, or is it just having it in place at all and giving them access? Does the same thing go for sales training? Like if there's Adam Bensman, he does a lot of YouTube training on sales, right? So if I send my team a link, because I find this very helpful, this is how I learned to sell. I send them a link. We're not coming into the classroom, we're not going into the conference room and meeting about it, but like this might help you. Could that be perceived as the same thing?
It could be, but far less likely. Okay. Yep, absolutely. There is a difference, and like I said, it's going to be fact dependent and how the interviews go.
None of this is determinative, by the way.
Yeah.
Really. And so I'm telling you, I've had 2 or 3 in my career that were absolutely identical and totally different results because they were 2 different investigators. And I have to be open and upfront about that with my clients who are facing these scenarios.
Which sucks for us because it's like, hey, listen, there are really no hard and fast guidelines here. Like,
right, but you got to pay me anyway.
Right.
Just don't want to check that.
Yeah. That sucks.
It does suck.
That sucks. And I don't know any other.
It's like me selling SEO. Like they're like, well, when can I expect this? When can I expect this? All I can guarantee is we'll do the same for you as we've done for every other client.
And your results are going to be drastically different.
They may vary. It might take 6 months. It might take 18 months. We'll get there. I don't know what the roadmap looks like.
Yeah, that's why the attorney advertising, you always see prior results do not guarantee future outcomes. Yeah, because it's the truth. And it's, I can give you percentages and tell you what I think is likely to happen. And the further in we get with an investigation, we can read the tea leaves and say, hey, look, this is not going well.
Yeah.
Let's make an offer to settle.
Yeah.
Or it could go the other way, and we could say,
yeah, this is going really well.
Let's hold out as long as we can and do what we can. But if you caught what I said, the fact that there are going to be employee interviews, I think that's critical to at least highlight, is that at the end of the day, if you have people loyal to you and you are treating people decent, that will go a long way in protecting you, because these regulators and investigators will be talking to your employees if there's a complaint, and it's going to go a long way if you can treat them right. So that's my pitch, to kind of just be, and it's a selfish motive, right? It's not truly altruistic. I'm not paying them more and treating them well because I'm a nice guy. I'm doing it because it's ultimately going to insulate me on the back end if things do go south.
Do the right thing. 6th core value out of 10.
Nice. So I'm going to put this into, I guess, maybe a little bit of a neat package so contractors can understand. You can have 1099 salespeople. You can. Sure. It happens. It works. But it's really going to be sort of a free-for-all, meaning if you're in a state where there's no contractor licensing, then this truly independent person at some point is probably going to look at you and say, why am I working for this person when I can duplicate exactly what they're doing, leave, and do this on my own? I just need to find a crew, because why should I stay working for this guy when I'm still taking, all the upfront work of generating my own leads, using my own tools and technology, finding out how to do everything on the front end, write the contract with the homeowner, do all that stuff. Well, what do I need this company for? Right.
Or not leave and just do it on the side. Take your leads and sell them to the other company.
Oh, like what happened to me. One of the other reasons why I decided to go to W-2, even though you're bound by a contractor's license in the state of Florida. What it didn't stop was this other individual, who, by the way, I spent a lot of time developing. They went and started undercutting me with their buddy who opened up a contracting business. And you can't stop that if they're truly independent. Now, if they're W-2, there can be repercussions for that. And so for me, the control, because really it comes down to, and I don't want to use the word control in like a negative, connotation, but control meaning I can get everybody doing the same thing, rowing in the same direction, setting up standards, and making sure that we're all following the same path so that we run a more streamlined company. It's much, much harder to do that on a full independent basis because now you have different people with different personalities, different ideas of how things should get done, and you kind of have to let them do it or you're violating the rules. Do I have that right?
You do.
Okay.
Yeah, that's perfect. I really like that.
Okay.
That's a good explanation. And, I think when people are selling your leads or undercutting you, regardless of whether they're an independent contractor or a W-2 employee, that sucks. And it's going to happen. And that's just sort of the cost of doing business. I mean, the lawyer in me wants to say, well, even an independent contractor, we could have a non-disclosure confidentiality agreement. Maybe they violating a trade secret law by misappropriating your trade secrets. But the truth is that getting a court to rule in your favor on that is going to take 2 to 3 years and
A lot of money
in legal fees. And at the end of the day, if you are successful in proving that your sales records were true trade secrets, which is not guaranteed, and even if the court awards you damages for that misappropriation, right? The amount of sales that were taken from underneath you, so to speak, you have to recover that judgment. And good luck.
Like a career 1099 guy.
Right. Yeah. Yeah, exactly.
And you might be sitting here watching this episode thinking, my sales team would never do that to me. My guy to my left here thought the same thing. He invested a lot in this particular individual. From what I understand, you may have maybe even sent him on a honeymoon.
Paid for his honeymoon? Sure did.
Nice guy, just trying to do the right thing.
Did. Yeah.
The name's in the comments. I'm kidding. It won't be there. Yeah.
Right. Yeah. And if you think what is the saying? If tall fences make good neighbors.
They do.
Yeah. And it's the truth. I mean, you can trust people all you want and be, friendly, but like you said, when it comes to money, people get weird.
At the end of the day, what I've learned is, the larger you grow as a company, the more people you have working for you. And anybody that knows me knows that I've really tried. I treat my people really well. I train them really, really well. I want to set them up for success. And like you said, it's not necessarily altruistic. The more successful they are, the more successful I am. So it's a mutually beneficial situation. But what I've learned is over the years, people will, as soon as things aren't going exactly right for them, they're going to look for reasons why you're maybe not the right person and how you're screwing them or whatever. And they stop looking at their behavior and what they're doing. And then all of a sudden, when there's an opportunity for them to look out for themselves, they will. Yep. Do I fault them for that? Maybe not, but it does happen. And at the end of the day, I learned that I just need to protect myself across the board, period.
Trust nobody.
Yeah. I don't know that we need to go all the way there, but trust but verify. How about that?
You're the IRS now.
Yeah. Right.
All right. Trust no one.
Yeah.
I'm going to send that clip to my therapist. Trust nobody. He's going to want to talk about that.
So let's talk a little bit about what...
Tell me about how it roots back to 1989. The fuck out of here.
You have unresolved childhood trauma.
Yeah.
So let's talk a little bit about how these agencies enforce these guidelines.
Sure. So they're gonna, if a complaint is issued, they will assign an investigator. That investigator reaches out and says, we've received a complaint. Depending on the type of complaint it is, you typically have between 10 and 30 days to respond. That's when you call your lawyer. He or she reaches out to the investigator and says, hey, I'm just getting caught up to speed. Can we get a little bit more time? They're going to ask for documents and records. Depending on the type of investigation, there most likely will be interviews of your workers. You yourself, as the business owner, will have to sit for that.
Let's say your records aren't really great and you don't have a fine point on everything. Does that go against the investigation or the contractor?
That goes against the contractor. Yeah.
I'm just clarifying. Just wanted to make sure.
So there's, I'll give you an example, right? There's a presumption that if certain records are not being kept it's because they're being faulted. So if you're saying, I swear we give these guys a lunch break, it's just not in the records, they're going to presume that you don't actually give them the meal break. And that.
So there's no innocent until proven guilty on this?
No. In fact, in New York, for example, there's what's called, and this term is just incredibly ironic. The term of the statute, or the name of the statute, is the New York State Fair Play Act, Construction Fair Play Act. And it, from my perspective as a business attorney, it's not fair at all, but that's what it's called. And what it means is, in the construction industry, your workers are presumed to be employees. They are not presumed to be independent contractors. They're not even presumed to be nothing at all, and it's going to be up to either the investigator to prove one or you to prove the other. No, you start out at, they're presumed to be employees, and it's up to you to tell us otherwise.
And that includes your sales team.
Sure.
Okay.
Absolutely. Absolutely. And I think that the where people will get caught up with that is, they're not technically listed in the statute as being covered by it, but in practice they absolutely are. I mean, if you are out there selling shingles, guess what? You're going to be covered by that law in New York State. And you as the employer, this is the other piece. Once the complaint is filed and once the investigation is ongoing, they're no longer just looking at your sales guys.
Right.
They're looking at everybody.
Yeah, they're looking at your labor. They're looking at your office staff. I literally have heard people that have 1099 project managers, and I laugh.
Yeah.
I'm like, how do you even justify that?
Yeah.
Like, there's no justification for having an admin person that works in the office as a 1099.
Yeah.
Like, you're clearly just trying to pay them and not pay taxes on them.
Yeah, in most instances, I think that's right. I mean, the only time I could maybe see that would be if it's truly for like big projects, and this person is truly coming in for one project. You've never seen her before. You'll never see her again. She has a separate business entity. She controls not only the result, but how she does her job. Then maybe.
That's just a consultant, though.
Exactly.
That's not going to be an admin, right?
Right.
Yep.
And so, it's problematic. And I know New York is not the only state to have these Fair Play Act type of statutes on the books where you are presumed to be employees. It also applies in the transportation industry. I mean, it's growing. That's the other piece, is that I've been doing this for 10, 11 years. And even in that short amount of time, relatively short amount of time, I have seen the trend. And it is going more and more employee friendly. When I was in law school, it was starting to go that way, but it was still kind of business friendly. It's not anymore. And it's going in the direction pretty precipitously of pro-employee, which I'm all for employees.
Sure.
I'm all for employee rights. But the pendulum is swinging, I think personally, a little too far in that direction.
Okay, so before we get into that, because we're going to talk about, there's some rulings that have come recently, and there's some different guidelines and things like that that are going to happen. We'll talk about that, but so let's get back to how these agencies enforce this. So they do an investigation, they go in, they talk to your employees, they look through your records. There's no presumption of innocence. There's actually an uphill battle that we have to do in the construction industry, which we have to prove otherwise that they're not employees. And that's a big distinction, guys. We have to prove they're not employees. Okay.
Right.
That depends on the state, yes?
Yeah. Yep.
Okay. Yeah. It depends on the state, but I would imagine that with those in the books on a federal level, they're still going to be looking through that lens.
Absolutely. It's just codified in a law in New York State and other states. But that is absolutely it. You are on the defensive once you get that call or receive that letter from these investigators. And there's a settlement discussion period pretty early on of,
because it's about the money,
right? Of, hey, here's what we're seeing. What do you want to talk about? And then they issue after their investigation is over, they issue their decision, and it's usually in writing, and will set forth, the number of violations, the nature of the violations. Anything that was not substantiated will be at least listed, and then the penalty. And then there's usually a period, sometimes 10, sometimes up to 30 days for you to appeal and say, we want to talk. And the appeal usually looks like,
a settlement
yeah,
offer.
I've had, right. So, OSHA, for example, the maximum award per violation or fine per violation is $14,000 and change. It's a weird number. And, say that you get, and that's just for one violation. So,
If you have 30,
can be hundreds of thousands. But say you have just one violation for that max amount. It's $14,000. You got 10 days to talk to them. What I would do is call them up and say, hey, look, we get it. We're going to make some changes. We don't have $14,000 to put up. Would you take 5? And they say, nope, we'll take 8. And we say, deal.
Best I could do is 66.66.
Right. And 66 cents. And then it's papered. It goes away. I mean, it doesn't go away. It's still a notice of violation in that instance, but the investigation is at least over.
Is there a double, like a kind of a comparable, like double jeopardy type thing there?
Yeah, more or less, right? So when you enter into a final order or a settlement agreement with one of these agencies, it does release, they are releasing you from liability for that violation.
From all other agencies as well?
No, only the one.
Great question. Great question.
Sure that we're
Nice try. Nice try. It's very clear in those agreements that this is only a release for the items that we're fining you for. And it's not a release for things that we don't know about yet, even if they occurred in the past. So private parties, you and I get into a settlement agreement together, typically, literally 9 out of 10 times, the release language is, I'm releasing you from any potential lawsuit I may have had against you from the beginning of the world,
period,
till the day we sign.
Right. Doesn't matter what it is.
Right.
Yeah.
That's not what the government enters into with you when you sign these things. It's, we're releasing you from these violations and
That we've caught you for.
Correct.
Yeah.
Let's say I'm a contractor and I have a very large appetite for risk, and I'm going to roll the dice, and everyone's going to be a 1099. Mm-hmm. And, I'm 2-3 years in, and I get notified. I get that letter. It's like, shit. And why don't I just close up my business, open under a new name, and, let that ride with the other company?
That's a great question. I mean,
is a great
does the corporate veil protect you?
No, it absolutely would get pierced. And if you were to, file for bankruptcy or, dissolve that corporation, there could be what's called an adversary proceeding brought in that bankruptcy, where you say, "Hey, I'm bankrupt. I stop all debt collection.
I have no money. Help me. I'm poor."
Yeah, and this creditor, in this case, it would be a potential creditor. One of these agencies can file an adversary proceeding against you in the bankruptcy and say, "Yeah, that's all fine and well, but we think this was a fraudulent bankruptcy or a fraudulent dissolution, and
because of the violations."
Right.
Okay.
Yep. And that's typically not going to happen unless and until they find out that you've opened up shop down the street with a new name. If you really are just going under and saying, we don't have any assets, we don't have any money, this is bankrupting us truly, they'll let you slide. I mean, they're not going to go after you personally for a judgment unless, it's a really egregious violation and you're a sole proprietor or a DBA, which you should not be. Right. FYI.
Because you have no corporate veil at that point.
Right. Yeah. In that case, maybe they would. But if you're an LLC or an Inc. and you really do dissolve over it, it's probably going to go away. But when you reopen under a new name, that's coming back up. for sure.
So I'm Jim's Roofing. I go bankrupt after this notification of this potential fine, and then I open up Jim's Roofing and Exteriors 3 days later. That's a problem?
That's a problem. That is a problem. And for, depending on the amount at issue, if it's a, potential $5,000-$10,000 violation, maybe it goes away. But if it's anything significant, I mean, they have endless resources, right? Their lawyers are already paid for. Right? And it's with taxpayer money.
Your money that you paid in taxes.
Yeah.
What if you don't pay? Is there a debtor prison?
No, there's no debtor prisons, but they can certainly get a judgment, and they can certainly enforce that judgment by doing things like
IRS liens,
UCC liens, IRS liens. Yep, they can. If you have equipment, they can seize that equipment. Any tools, things like that. If it's going towards satisfying the judgment, if they follow all the steps, they can absolutely seize that and sell it at an auction. And, they have to do that in a commercially reasonable way. But, if you've got $100,000 excavator, they can seize it.
Sell it for 18 grand and you still held the difference.
If it's deemed commercially reasonable and they want to get their judgment, you can get pennies on the dollar for your stuff. And, which leads into a whole bunch of other issues. If you lease that thing, don't own it, and it's messy. It can get real messy really quickly. Thankfully, there are no debtors' prisons, though, so you're not going to go to jail for this, folks.
Wow. All right, so it seems like that's really not. I mean, if you're a smaller company, this might be a risk that's worth taking, possibly.
Sure.
Right.
Sure.
If you're doing a little bit more, you have, more than four, 5, 6 people working for you, it might not be something that you want to, what you want to take on is basically what you're saying.
Yeah, I think that's right.
Okay.
I think that's right. And it depends on the revenue that you're doing.
Yep.
But, I think the other piece is what is your ultimate goal? Is your ultimate goal with the business to build something and grow it and pass it down to, your kids or something?
Right.
That's a whole different ballgame than somebody who's trying to create a business, operate it for 2, 3, 4 years, and then sell it.
Sure.
To a PE group or whoever. Those are two totally different goals. And that's why, again, these cookie cutter answers are not helpful and can be very dangerous, because the person who wants to have this thing last forever and pass it on to his grandkids, that guy or girl has a very different set of goals than somebody who's trying to get in and get out and make a quick buck on the sale. There's nothing wrong with that.
That's a great point. I mean, PE, private equity, you guys all know, it's a really hot topic in roofing specifically right now. And, this is a good thing to talk about, actually, because I know a few companies that have been acquired, some larger companies that have been acquired, and I know some that have been turned down. And one of the objections is non-compliance with some of these laws, because these big PE groups know that
Look back period.
They have deep pockets, and they know that these government entities and these attorneys like to go after people with deep pockets, because that means that they're going to justify their existence with these large fines. And so even if your goal is to liquidate your company within a few years, you still need to think about your marketability with non-compliance of these laws.
Yep, absolutely. And if I'm a PE group and I've got 2 potential acquisitions and they're all things being equal the same, except one is compliant and one's not, I'm going with the compliant one, right? That's easy.
Yeah.
And you can't explain, I mean, you could try, but it's not going to be super persuasive to a PE group when you say, but this is the reality of it. There's no other way to make money. Everybody does it. Those things all may be true. Mm-hmm. Guess what?
They don't care.
PE group's not buying.
Yeah.
They're just not buying your business. And again, if you're not interested in selling, then none of that means anything to you. What do you care?
Yeah.
But if you are, those are considerations that need to be taken into account, because if you're trying to sell your business, one of the first things they're going to look at is what are your potential liabilities and where are you at with compliance. And so, there could be, it could be a little bit of a loss leader to convert everyone.
Sure.
But in the long run, if your goal is to sell, maybe it's actually a really, really smart investment.
While we're talking about that, I'm sorry, were you going to say something?
I was going to say I smell a part 2 coming on. I think that's all the time that we have for today.
Okay.
Great.
Okay.
Time flies when you're having fun.
Yeah.
I mean, I've learned a lot. Hopefully you folks have as well. Corey, I appreciate you coming in.
Yeah.
James,
been great.
I couldn't be more grateful for you sharing your time. I'm sure I'll get an invoice for it. If somebody in the audience did want to have you counsel them, per se, how would they go about reaching you?
Yeah, you can reach me at my email address, which is joconnor@phillipslytle.com. So that's
We'll put it on the screen.
2 L's in Phillips. Lytle is Lytle. Or you can call me at 716-504-5723. Be happy to help.
Thanks a bunch, guys. Truly grateful. And
Thank
thank
you,
you to
Mike.
the folks at home, and thank you to Roofer. And we gone.
5, 4, 3, 2, 1, 0.